continued. Let the record reflect the jury step down. Counsel remain along with the defendant. So you said there's more that you have to publish to the jury?
Yes, there's all the videos on the 9807 phone. The defense counsel needs to go over and I have to show them exactly which ones, and we have to go through those, and then we'll have to read
How
them.
long are the videos?
There's tons of them, Your Honor. So I have to prove it's the defendant's phone.
Thank you. So how are we going to handle this? You want to, have you seen the videos? I take it. I mean, you have them. They're set over discovery, correct?
Yes,
well, they're now isolating those that they intend to, and we'll make sure that we do what we need to do during the time limit. I don't think we need the court's intervention.
Well, this is my thought. If there's an issue about it, I don't want to have a problem with it. My thought is, if there is an issue about it, we'll resolve it and we'll do it on some date next week when we're off. We'll just pick a date that that everybody's good for, and we'll resolve it during that week if there's a problem.
Makes good sense to me.
What time do we have Friday? Have Friday issue? Any issues Friday? I know we have hearings.
In terms of the 6th, I believe I scheduled the depot for their defense witness.
I want to ask you about that too, but let me hold on. I just want to find out, make sure that we need time on that Friday. That is the 14th, I guess.
The 7th, Your Honor.
Next week. Friday.
Yeah, the 7th.
The
It's the
7th.
7th. I apologize. I'm looking on the week of the 10th. You're right.
7th is fine for the statement.
So could we clarify, because we were supposed to get a date today for the deposition, and now she's saying she's scheduled the 6th?
No, we're talking about the 7th.
We're going to get the depositions at the 7th.
Okay.
So, counsel, on the 7th, everybody's available on the 7th if we need it? So how much time do you think you need?
I have a 1 o'clock afternoon in the afternoon in 7th federal court, so something in the morning, and also I would need to be here if everybody else is.
So, how much time do you think you need?
I don't know if we'll even need anything, Your Honor, if we're planning on that, so.
So why don't we just plan on, if you need it, we'll do it at 11 o'clock?
Sure.
That'll give you an hour. Is that all right? Does that work for you?
Yes, sir.
All right, so we'll do it at 11. That's good for everybody, yes?
Yes, sir, that's right.
All right, on the 7th, and what I'm going to ask you to do is contact my office beforehand and just tell me, if you need the time or you don't need the time, all right?
Thank you very much.
Yes.
Now, what about the depositions? First, yesterday, I think, when Ms. Smith indicated to me there was a witness that stated, or I guess you did, Ms. Bradley, objected to the scheduling of the deposition without your knowledge and consultation beforehand. And Ms. Smith indicated she didn't believe the witness was going to show anyway because you would have been trying to get the witness to come. And he didn't. Is that deposition, what's the witness's name?
Crazy on glass, Your Honor.
And that witness looks like it's going forward, the deposition?
His sister called our office to ask if it was Zoom or if it was in person, and she was told that it is in person.
All right, so assuming this witness's deposition is taken, when is it set for?
Tomorrow morning, Your Honor. So Judge Gifford has been kind enough to move my hearings around. So for that, for Mr. Smith's case, so I should be available.
So everything's good?
Yes.
All right. Was there another deposition?
Yes, Judge, she had stated that she's having our witness depose on...
Who was your witness again?
That would be Larry Daniel, thank you.
Yes. I was told yesterday to pick a date and they would make him available.
That's the cell phone witness?
Correct.
The
And
expert?
so the first date I'm available next week is Thursday, the 6th.
They're good?
I will check with him, but this is the one that she wants him in person, and per the rules, 92.142, she needs to be providing his airplane ticket and his hotel.
Well, the court reporter is going to appear via Zoom, so I'll do it via Zoom on that. That's not a problem.
Okay, thank you. I'll speak with Larry, make sure he's clear, but I did tell him yesterday that it would be next week, so I'll confirm that and I'll let her know this evening. But it shouldn't be a problem.
And Your Honor, I filed a motion to compel any of the materials for Mr. Demons that he has done. Nothing's been provided other than a CD. So if he's relying on any demonstratives, anything else like that, that would need to be provided to the state forthwith.
Did you give a report or anything?
We did not give a report. We were fine with the FBI, and again, I had reminded the court she had given me case law last week, which now requires me to bring my expert. He is doing tests. If I get a report or any of the results back from the testing of these tools that he's using, I will definitely give it to her prior to him coming. I'll give it to her upon me receiving it.
My question was, do you know if he has a report as of yet?
Nothing as of yet, Judge.
So I'm hearing something about testing being done and things of that nature. So if anything is going to be done, it needs to be done and turned over, I would say, prior to the deposition, because they can't ask about something that hasn't happened.
I agree with you. Like you said, the minute I have something, if something is prepared, I will provide it for him.
Well, I guess the concern Bradley has is that if there's not a report turned over to her, and when she's walking into the deposition the first time that's handed to her, she's at a loss of a disadvantage is what I think she's trying to convey to me.
I promise I will not ambush the state, Judge. So as soon as I have something, if there's something created, I will give it to her within minutes of me receiving it. There's nothing else I can do about it. She wants to compile something that doesn't exist at this point.
So, Your Honor, my concern is it sounds like the expert was going to do some sort of testing once he gets here. That was how I took Ms. Liberty's last statement. So in that instance, what's the purpose of doing a deposition? If he's going to be creating new information or new reports as he's testifying. So I guess that's...
I don't know that that's what the intent was. I thought that was a generic statement as to what the witness may be. I don't know. There's no report now. You want to take his deposition. Obviously, if there's some, he makes a report or does some testing and it's not turned over to you, you don't know about it, and he's not explaining anything in the deposition, and you want a new report, there's new evidence, that'd be a Richardson violation. If you were saying there's a discovery violation, we talk about it, and you have a right, I would think, to cure whatever problem there is and redepose the witness, or if that happens, we'll make some accommodation. I mean, I would think that'd be appropriate.
I agree, Judge.
So let's just take it one step at a time. Counsel suggested she's going to turn over whatever she has as soon as she gets it, and I accept her representation. She also, Ms. Liberty also indicated that she was going to reach out to the witness, correct? You said to find out whether there's something's forthcoming. So we'll take that one step at a time, but I understand your concern. You don't want to be ambushed or sandbagged with a report and start asking questions and you haven't seen the report yet. So, let me know.
And so the other concern then becomes a potential Daubert issue. If he's doing some new testing or something like that, so that would have to be raised. If it's not been provided, I can't file a timely Daubert objection if I don't have the information. So just want to make sure that's clear for the record, Your Honor, is aware of that issue as well.
Let's cross the bridges as they approach.
I don't know what the issue is with the witness. You're saying the witness was never disclosed?
No, Your Honor, what happened was the witness was listed in, 2022. And if I'll pull up the email so I'm quoting exactly, I had his deposition scheduled for March of...
But just to move along, we were not going to call him because the FBI...
So you had him on the list, she's counsel scheduled for deposition, then you withdrew him as a witness?
Yes.
This is that witness, all right.
Okay, and then last week she gave us a case from Wisconsin on the Fitbit and the lay person. So I started researching the Fitbit and all the case law that goes with it. So at that point, based on her providing this case law that she's relying on, I now have to get the expert to test the Fitbit and the health app on the iPhone. So once I have those done, because she's going to go back to that motion, the same, we'll talk about the motion to come. I will guarantee the minute I have some type of proof, if he gives it to us, it will be provided to her. But that is the issue. She told us last week this is what she's relying on, and we have to prepare for it.
So in terms of, he's no longer a cell tower expert as previously listed. So that's what I was prepared to depose him on, was he was listed as a cell tower expert, and he was deleted as such in...
And now we're trying to list him as a Fitbit expert?
Well, she's going to, based on the case law she provided last week, yes, Judge.
So on Monday, March 20, 2022, Ms. Liberty emailed myself, Mr. Adelstein, Mr. Howard, and Mr. Haddad, saying we will not be using Larry Daniels for the cell towers. We will remove him from our witness list. Thus, there is no need for the depositions tomorrow.
Well, counsel suggested she did that. She said she withdrew as a witness.
Correct. So just so that it's clear on the record as to why the deposition wasn't done prior to the start of trial. So she has not yet listed him as an expert in new areas on that. So that would not be a Richardson violation in terms of that. So I would just ask if there can be some sort of proper as to exactly what he's testing or what he's doing on this particular item so that I could actually be prepared as opposed to going and thinking I'm doing a cell tower deposition next week.
So it's not about cell towers, correct? It's about Fitbit.
Yes, based upon Ms. Bradley's, the state attorney providing me certain case law is very specific to what she provided me. So he's going here and saying she's not sure what I'm making it very clear. That case is what we need an expert for.
I'm not familiar with the case, but let's take the case aside. This expert you have is in response. You're saying you're listing a new witness. You're listing him again only as an expert this time as the Fitbit.
Well, we'll use the word celebrate because she's going to get the health data off of the celebrate download. So we'll just call her a celebrate expert. Like exactly cover everything, and she knows exactly what she's preparing for to celebrate. And she is certified celebrate expert, and that is on the CV that was provided for her. So that should be no surprise.
I guess you don't have a report yet.
There is no report in existence as I stand here.
You don't know if you're getting one.
Exactly.
And so counsel's asking for a proffer as to what you believe this witness is going to testify to.
Celebrate.
Anything more than that?
No, it will be celebrated.
And when you say celebrate, what do you mean celebrate?
So we just sat through hours of her data. That's all from Celebrate. So
Understood.
she's going to try to.
But what's his opinion going to be? Maybe that's the better way to do it.
So his opinion will be on the reliability of the health data app that's on the iPhone X, which is the model of phone. I believe she's on those data down below.
So that's what he's going to share opinion on. That's what you retain him to do, render opinion in this area.
Exactly, Judge, yes.
Okay. So that gives you a little bit of heads up.
Okay, thank you, Your Honor.
And we'll see where it goes. And we'll take it one step at a time.
Okay, thanks, Judge.
Anything else to discuss?
Yes, sir.
You're a wonderful point.
Happy for.
Oh, by the way, thank you, but this motion, you filed this motion about a jury view? Is that right?
Yes, Your Honor. So I was trying to see if we could take defense counsel down to look at the vehicle, but it's my understanding they've put it back into storage.
It's not there anymore?
No, that was what Sergeant Colliard with the Broward Sheriff's Office Crime Lab told me when I asked about that on a break.
So is this jury view item moot now? Not going forward with it?
Well, not for today. At this
For
point.
any day?
So no, we could do this on another date when we return.
So the date I gave you for the hearing, just plan on being there. We'll argue whatever motions there are. If this motion's pending, we'll argue the motion.
Yes,
All right? We're going to jury review on that Friday, 7. Okay?
Maybe we
11?
can take a look at the vehicle sometime next week.
Good? Good, everybody?
Yes, sir.
All right.